Judge Glacier, we're a few minutes early, but I just wanted to let you know that we have representatives for both sides and the reporter ready whenever you.
Okay, great. Well, let's proceed. You can bring them all in, if you would, Morgan.
Hi, Judge.
Good morning.
Hello, Your Honor.
Good morning, everyone. Good morning. Good morning, Mr. Khan, too. Happy New
Good
Year.
You too.
Thanks. So I want to, well, let me call the case. This is Atsalis Brothers Painting Company versus Michigan Department of Transportation. It's case number 20172 MK in the Court of Claims. Good morning, Ms. Roberts.
Good morning.
Happy New Year to you too. Glad to see you this morning. There are two motions for summary disposition before the court. There are at least 6 motions regarding discovery issues before the court, which the court is not going to address today, other than in a sort of global sense at the end of the summary disposition hearing. And the court is I'm going to give you sort of my sense of where we are on these motions for summary disposition, and I'm going to propose how we address them this morning. So there are 2 motions for summary disposition, one filed by the department and one filed by Atsalis. The department's motion focuses on, as I understand it, the scope or the amount of the payments required after a termination for convenience. And when I say the scope, I mean the legal definition of what the termination for convenience language requires in terms of what's owed, basically. The second motion, filed by Atsalis, concerns whether the department had a right to assess contractual liquidated damages when it terminated the contract for convenience. So I'm going to propose that in fact, I'm going to ask that we address the second motion first, because to me, that's the easier motion, the simpler one, and I'd like to get it out of the way at the outset. And I'll let you know what the court is thinking, so that, hopefully it's helpful in shortening or focusing you in these arguments. As I understand it, and Mr. Vitiglio, you can help me since you're going to speak first here, by correcting anything that I have misunderstood or misconstrued from the briefs. That in this liquidated damages argument, the amount at issue here is $388,700. And the liquidated damages that are claimed basically arise from an alleged failure on the part of Atsalis to timely complete the work and open the bridge for traffic, loosely. Atsalis argues, and I'm inclined to agree with Alice on this point, but I'd like Atsalis to expand on its argument and address a few points that I have, that liquidated damages cannot be assessed legally in this circumstance because the department terminated the contract for convenience. It seems to me that the department had a choice when things went south or when things soured with Atsalis. It could have invoked the default of contract provision. It probably had grounds to do that, at least were I to view the evidence in the light most favorable to the non-moving party. It seems to me that the department had grounds, but it didn't do that. It didn't invoke the default of contract provision, which I view essentially as a fault provision. Instead, the department decided to rely on what I'll term a no-fault provision. It strikes me as a no-fault provision, and I have to say that I was helped by this best foam case, which I think really does explain in very down-to-earth language what a termination for convenience provision is all about. And it does seem to me to be a no-fault provision, which means that as best foam states, the department, let's leave that for the next argument. But if this is in fact an appropriate way to look at the situation, it would seem to me that the department's complaints and requests for liquidated damages or any other type of damages against Atsalis essentially dissolved when the department made the decision to invoke the termination for convenience. So with that as a preliminary, Mr. Vitiglio, what have I missed? What have I gotten wrong? And why don't you respond to what you anticipate the department's arguments will be in response to what I have just said?
For the record, Anthony Vitilio for the plaintiff, Your Honor. It may have pleased the court. I believe that your analysis is generally right in line with what we believe to be proper. The reference to best foam, Your Honor, I don't think we need to get there in this context because Michigan law controls the outcome of this motion. We've cited case law going back to 1914, Your Honor, where liquidated damage clauses are held to be unenforceable and void when matters outside the control of the contracting party force that contracting party to be late in its performance. And the most recent on-point decision is the Grand Rapids Asphalt case. It's a published decision, Your Honor, where a contractor sued the city for withheld liquidated damages, and the Court of Appeals held that the city was not within its right to withhold liquidated damages because there were reasons beyond the contractor's control that frustrated its performance.
But that wouldn't that then require me to that to me means that there are questions of fact here about whether or not there are. So you're essentially, Mr. Vitilio, it strikes me you're arguing against yourself here in a sense. Either you want a legal ruling that that the department is not entitled to liquidated damages, or perhaps you want a hearing on whether or not there were circumstances outside your client's control that underlie the department's claim for liquidated damages and therefore eliminate that claim. I mean, which do you want?
Well, Your Honor, what I was going to say is that our case is stronger than Grand Rapids Asphalt because there is no factual dispute. All the court needs to do is look at the language of 108.12a, reasons for termination. And all of those reasons, Your Honor, are beyond the control of the contractor or the department. And that's exactly what the contract says. The department may terminate the contract after determining that for reasons beyond either the department or the contractor's control, the contractor is prevented from proceeding with or completing the contract work. So there are no factual issues here, Your Honor, to resolve. The only important fact that's undisputed, and that's the only material fact for determining the outcome of this motion, Your Honor, is the fact that the department irrevocably invoked 108.12 And by doing that, they have expressly acknowledged that there were reasons beyond Atsalis's control from performing the work. Then we fall right in line with Michigan law that says when such reasons exist, liquidated damages are void and cannot be assessed.
But it seems to me that the language you just read is forward-looking rather than backward-looking. And the department's claim for liquidated damages relates to things that happened in the past rather than going forward. And have I misconstrued the claim?
Well, I think so a little bit, Your Honor, because everything, to take a step back, you have to consider, Your Honor, that on a construction project, the contractor is working progressively. And so when the department invokes a termination for convenience clause, of course, they're looking backward because that's when the impacts were suffered by the contractor working on the project. That's the whole point of the termination for convenience, is that when the contractor is working and is being impacted for reasons beyond its control, the department has that drastic right to terminate all or a portion of the contract precisely because of the exigent circumstances that the contractor is facing. So it's backward looking, it's forward looking, it's living in the present. It's the department recognizing there are big problems here that are outside the contractor's control and outside the department's control that warrant a termination. And so with that recognition, based on the plain language of this contract and applying that to Michigan law, the Early v. Tussey and Grand Rapids Asphalt hold that liquidated damage provisions cannot be enforced against a contractor in situations where they've been prevented from performing. And there is no factual issue to resolve because that's what the contract says under 108.12a. It was
Okay, I get it. Let's save your time, or you don't have time. You're going to have as much time as you want, but I think it would be more productive at this point to hear from the department, and I'll let you respond, okay?
Thank you.
Thank you, Your Honor. For the record, I am John L.A. Tuttle, appearing on behalf of the Michigan Department of Transportation. And with me is co-counsel Eric Kwan.
Morning, Your Honor.
Morning.
A few points, Your Honor, and the first one being that liquidated damages per the contract are assessed the moment the condition arises. And the condition here is not completing the work by October 14th, 2019. So as long as there was on October 15th, 2019, if there was work existing to be done, the conditions met and damages were assessed.
Did you give them notice of that in 2019?
Yeah, they're automatically, they're per the contract, Your Honor. Notice is not required. They're not part of the default provisions. They're not part of the termination for convenience provisions. They're a separate provision that allows the assessment of liquidated damages the moment the condition is met. Atsalis misunderstands the way in which they work here. If I may, I do believe the court may have a misunderstanding as well, because the necessity to have the bridge open to traffic is not part of it. So the bridge was always open to traffic. By contract, they were required to keep a lane of traffic open. So it was always open to traffic. The provision, if you look at the liquidated damages provision, there's two types, and that is whether, the need to have the work completed and also the need to have the project open to traffic. For instances where the project needs to be open to traffic, that's often used in road construction, meaning you have to get the road up and running. Here, this was just work that had to be completed. Under the progress clause of the contract, work had to be completed. The two phases of the cleaning and coating work had to be completed. First phase had to be completed October 14th, 2018. Second phase had to be completed October 14th, 2019. When Atsalis requested to work through the winter shutdown on the first year, liquidated damages were waived. When Atsalis requested to work through the winter shutdown on the second year, they were allowed to work through the winter shutdown, but they were expressly told that liquidated damages would not be waived. And they understood what that they understood what that meant, because they immediately responded and contested our ability to assess liquidated damages based upon their extra work claim, and their claim that the reason they couldn't complete the work was because they were being required to do extra work.
Well,
But
let me ask you this. Could you have terminated the contract based on, for default, based on that, for lack of a better word, breach on their part?
Yes, I believe so, Your Honor. Yeah, at that point, that
Okay, but then it seems to me the contract gave you two options: termination for default and collection of liquidated damages, versus termination for convenience.
well, Your Honor, they asked MDOT not to terminate for default. That situation had arisen, and they requested not to be terminated for default, and they requested the opportunity to continue to work. They understood, Your Honor, that liquidated damages were something immediately assessed when the condition arose, and that they're in the contract. They're separate from a termination. The whole issue of terminating for default and the whole issue for terminating for convenience are completely separate from the assessment of liquidated damages. The provisions are separate, and the way in which they are assessed is separate. What you're allowed to receive under a termination, what MDOT would be allowed as damages under a termination for default are different than liquidated damages. Liquidated damages, Your Honor, are completely separate. And some other points, Your Honor, we agree that the issue of whether there's a matter outside of Atsalis's control, according to their theory, we agree that that's a factual question. But we also agree that it's pure speculation on their part. If you look at 108.12a, which they rely on, that's the whole crux of their argument, Your Honor. Their whole argument is based on this notion that by invoking termination for convenience, it's somehow an admission that the contractor was prevented by means outside their control. But that's not what 108.12a says.
Yeah, no, I don't buy that either. I mean, I think that that's not an admission, because I think, as I just said, this is a no fault provision. It doesn't mean that you said that the department says we screwed up. It doesn't mean that Atsalis screwed up. It's a decision that absolves everybody of fault and says, basically, let's move on. And certain payment provisions, which we're going to get to in a few minutes, will then kick in to decide how we divide up the monetary responsibilities for the choice the department is entitled to make. So yes, that's what it seems to me that this contract provides for.
We agree in the main, Your Honor, but we disagree that liquidated damages can't be assessed as the contract goes on. For example, had we not waived liquidated damages in 2018, they would have been assessed and they would have been offset against the payments made to the contractor. The contractor could have continued to work for several months and then also been terminated for convenience. And that doesn't mean that suddenly they have all of the liquidated damages revoked at that point.
You could have assessed the liquidated damages by withholding them from payments made before you terminated the contract for convenience. And I don't know, I'd be interested to see I would think that would be appropriate. The question here is whether you can invoke the liquidated damages provision after you have terminated the contract for convenience.
Thank you, Your Honor, for that distinction. So to be very clear, Atsalis is contesting liquidated damages that were assessed for work done prior to the termination. No liquidated damages were assessed for work after the termination.
Well, okay.
Granted, but you are correct that in the post-termination compensation, MDOT was required to pay for work that was completed. They found the work that was completed that was unpaid for, And then they found that there were liquidated damages that applied to that work. And then they took that out. And the amount is $138,000. So the amount that Atsalis is now contesting includes liquidated damages that were assessed and applied before termination. The only amount that were so the 138,000 was assessed before termination, but only applied after termination. And if it's Exhibit 6 to our motion, Your Honor, it is the termination compensation letter, and there is a table attached to that letter that we can go through. I don't mean to give you too many details.
Let me
Yes.
stop you, Mr. Tuttle. Are you saying it's 188?
So it's 138,000.
Okay.
Those were the ones they were assessed for work done before termination, but they weren't applied yet because so the termination happened and there was still some payment due to Atsalis for work that they did. So they found that work. They said, okay, we're going to pay for it, but there's still liquidated damages applicable to that work. So we deduct that as liquidated damages and we pay. So you're right that they were applied after termination. They worked to reduce post-termination compensation, but they were assessed for work that was done prior to termination. So there was the balance then, the 388,000, I forget the exact number. The balance then left over after that 138,000 is subtracted. That balance had already been assessed and applied before termination for convenience.
Okay.
It had already been all worked out. The other thing.
Go ahead.
Okay. The other thing I would like to mention is that the case Best Foam Fabricators it does deal with a different kind of contract. It deals with a true fixed fee contract, meaning it's a contract where, no matter what you do, no matter how much work you put into it, this is the fee. You don't measure out the work and issue a payment. And so that there's some differences in the contract for that. And there's also, well, I don't want to go into it because perhaps it's a matter for the second motion, but I do just want to point out that it is a different contract that Best Foam Fabricators is dealing with.
Okay. Mr. Vitiglio, your response?
Briefly, Your Honor. Your Honor did have it right in your introduction. The total amount of liquidated damages was $388,700. And I don't see a distinction between when they were assessed, when they were applied. It just doesn't matter for purposes of the legal determination of whether they can be assessed at all in light of the termination for convenience and what that contract provision says. Of course, we're relying heavily on 108.12. That's the whole case here when it comes to what were the rights and obligations of the parties under this contract when it was invoked. Two other quick points, Your Honor. You mentioned, could they have terminated for default? Yes, they could have, but there was a third option, Your Honor. And the third option was just continue to direct Atsalis to continue performing pursuant to its claim rights. Instead, the department elected to terminate for convenience to mitigate its costs moving forward. And my last point, Your Honor, is the department, in its written briefs and here at oral argument, they have no answer for the case law that we've cited, early v. Tussle and Grand Rapids Asphalt. It's controlling, and we would ask that the court grant the motion.
Okay, thank you. That argument was helpful. I'm not sure that it was helpful in terms of enhancing my understanding of the facts. I'm not sure that it helps me determine that there are no facts at issue, unfortunately, but I'll look at everything. All right, let's go to the more difficult of the two motions, which I believe is the first one brought by the department regarding the scope of the payment, but you probably have a better way of putting it, that's required after the termination. And it seems to me that when it's all boiled down, this argument really centers on how the court will interpret the final sentence that's at issue. But if I'm missing something, again, you can point it out to me. The department will pay for pay items eliminated in their entirety by the termination in accordance with subsection 103.02F. That seems to be where the disagreement lies. That is, what is a pay item? How do we interpret that? But again, if I'm missing something, I know you'll set me straight. So who's going to argue for the department?
I'll be arguing again, Your Honor.
Great, thank you.
MDOT's motion is a motion for partial summary disposition under C8 and C10. And you're correct, we're seeking two separate types of relief. The first is a purely legal ruling on the operation of standard specification 108.12. It's based upon the face of the contract. The second type of relief we're seeking is a ruling that Atsalis's post-termination compensation complied with the contract, and therefore count one should be dismissed. The first point I'd like to make, Your Honor, is that the court can make this ruling because the costs for which Atsalis is seeking reimbursement are for completed work and are therefore paid under contract unit pricing under standard specification 108.12. So in other words, the Atsalis's costs don't pass 108.12's threshold question to get to 103.02F. And because they're covered by unit pricing and not compensated directly, the factual questions of whether they are truly costs incurred on a pay item are now immaterial. Before I get into the specific phrase that you rightfully brought up as the whole crux, I just want to make this point because I believe it's important. And that is that it's because the costs were for completed work and not for entirely eliminated pay items that there's no question of fact, right? Because the costs were, let's put it this way, if the costs were actually incurred on a particular pay item that was entirely eliminated, that's something that Atsalis would have to substantiate, which they have never done. They admitted that they've never taken the costs in their 1,700 pages and demonstrated that they were for this particular pay item incurred on this pay item that was entirely eliminated. The reason you can rule on this motion is because they admit that it's for completed work, and because it's completed work, they're paid under contract unit pricing, and that need to substantiate the costs is now immaterial, and there's no question of fact. So when Atsalis makes the claim that MDOT agrees that there's no questions of fact here, we do, but we agree under MDOT's interpretation. So moving on to the question that you raise, Your Honor, and I think it's a very important question, because a great deal of ink has been spent writing about 108.12's limitation on direct costs, and that they're paid only on pay items that are eliminated in their entirety by the termination. And that's the key phrase here, Your Honor. The key here is that phrase is 7 words long. It's not 4 words long. So the proper interpretation of the contract must account for the whole phrase. Only pay items that are eliminated in their entirety by the termination are paid under 103.02F. So when work is under a pay item, when work is completed, there's no further work to perform, right? If you do all the work, there's no further work to perform. So in a sense, you could say that pay item's been eliminated, but not by termination, by performance. So when some but not all work has been completed, then you can say it's partially eliminated by performance. So a subsequent termination then eliminates only the remaining portion, not the entirety of the pay item. And that's exactly what happened here. The costs for which Atsalis is seeking compensation were not incurred on pay items that were eliminated in their entirety by the termination. The pay items that they're seeking compensation for are the cleaning and coating work, the work they completed, partially completed. And so those pay items were eliminated by a combination of performance and termination. And so to account for the phrase eliminated in their entirety, Atsalis gives an overly simplistic and I believe an ultimately inadequate definition, right? They say a pay item is eliminated in its entirety when there's no further work to perform under that pay item, right? Well, what they're trying to do, Your Honor, is they're trying to say that eliminated in their entirety includes eliminating only a portion of a pay item without actually saying that they're saying it includes elimination of only a portion of a pay item. And a portion of a pay item is by definition not the entire pay item. Now, another point, Your Honor, is that, you know, to the extent that the court may find that this phrase eliminated in their entirety by the termination, to the extent that the court may find that this phrase is ambiguous, and MDOT doesn't believe that it is, Atsalis expressly agreed that MDOT had the right to interpret the contract. In 104.10, I believe it is, there's extensive provisions that any ambiguities in the contracts, any problems in the contracts, MDOT has the right to interpret that. They even cite this in their own brief. MDOT interpreted the contract when it paid Atsalis' post-termination compensation by paying for completed work at contract unit prices. Now, Atsalis, in its response to MDOT's motion, it attempts to establish that MDOT interpreted 108.12 before this moment in its termination letter. So in MDOT's termination letter, MDOT said that the contract was terminated in its entirety. And Atsalis latches onto that. But here's the distinction, Your Honor. Saying that a contract is terminated in its entirety is not the same thing as saying that a particular pay item is eliminated in its entirety. A contract is a legal instrument. A pay item, by definition, is an item of work. So by saying that you've eliminated the contract in its entirety is not the same thing as saying you've eliminated the pay items in their entirety, because pay items are items of work, and some of the work had already been completed. It could not be eliminated by the termination. The termination did not wipe out what they did. If it did, then why do we not have all our money back? Why are they even asking for money if somehow the termination wiped out the work that they did? So here, Atsalis performed roughly half the cleaning and coating work. And so while MDOT terminated the entire contract, right, that termination didn't eliminate the cleaning and coating pay items in their entirety. It only eliminated the remaining portions. And eliminating the remaining portions is not eliminating the entirety of the pay item. They were only halfway eliminated. And I do believe I need to state that Atsalis' reliance on 103.02F completely ignores the provision for paying for completed work by contract unit pricing. And I don't think that can be said enough, but I do think the court already understands that bit, and so I won't go over it. I am fully prepared to go over all of the post-termination compensation and explain how each was paid. Our motion does this. I can do it again if you'd like. We're prepared. Okay, I took the cue from the court. So I would then like to wrap up by saying that MDOT's interpretation is the correct interpretation. It takes into account the entirety of the contract's provisions.
Okay, let me stop you for a second. Let me just ask you this. If the court agrees that MDOT's interpretation is the correct interpretation, has Atsalis raised factual questions that would then require fact-finding regarding the application of the rule or of the interpretation that you're propounding?
No, Your Honor. And the reason is this: there are factual questions. They result from the extra work claim. And this is an important point to make too. The court can interpret the termination provisions, and it can rule on MDOT's application of those provisions when it paid post-termination compensation. And it can do so even though Atsalis has an extra work claim still pending. The extra work claim does not need to be decided now. So count 2 and some of the related counts after that would still be live if the court decided count 1. Now, granted, Atsalis does bake into count 1 its claim for a whole bunch of more payments, but that could be accounted for by going through count 2. Because really what's at issue here is the post-termination compensation based upon where the contract stood. So the court can decide count one without deciding the extra work claim, figure out if we paid post-compensation termination correctly, and then the court can then move on to figure out if we correctly denied their extra work claim, or whether that extra work claim whether more payment should be made on that extra work claim. And so the reason there's no factual issues, and this is important, Your Honor, for count one, the reason there's no factual issues is because Atsalis time and time again says that it's seeking payment for completed work. Its costs relate to completed work. If the costs relate to non-completed work, we would agree, factual issues, because then Atsalis would have to come forward and show this cost was incurred on a completely eliminated pay item. This cost was incurred on a completely eliminated pay item. But they haven't said that. What they've said is we're seeking payment for costs we incurred for all that work we did over there. They're trying to use it as a loophole to overcome the denial of their extra work.
And you're saying that you get paid for that based on the contract price?
Yeah, yes. So
I get
there
it.
is,
I get it.
yeah.
Okay. All right. Mr. Vitiglio.
Yes, Your Honor. May it please the court, in connection with the MDOT's third motion for summary, we're asking for the court to enter judgment under 2.116 I2. And the question before the court, Your Honor, is whether the department was obligated to compensate the contractor a fair and equitable amount for all direct costs incurred on the item prior to the elimination of the pay item, after the department terminated the entire contract for convenience and all pay items were eliminated in their entirety with that termination. The analysis, Your Honor, should start again with 108.12, termination for convenience. And I recognize that you see a distinction between fault, a termination for fault, and a termination without fault. And I agree, if we want to call the termination for convenience no fault, that's fine, because the termination arises for reasons beyond either contracting party's control.
But Mr. Vitiglio, it's termination for nobody's fault and nobody's special benefit. And it seems to me you're arguing that if they decide to invoke a no-fault provision, you get the benefit of what you would potentially reap had there been a breach of contract action, and you convince the court, you know, that you were entitled to some other types of damages. That argument doesn't really resonate.
Your Honor, there is absolutely no benefit befall on Atsalis.
Yes,
they
but
have incurred $16 million in hard actual costs that have been paid out while attempting to perform the work as directed by the department.
Well, let me stop you. Let me stop you, because it seems to me then Atsalis had potentially a right, and that is under the contract to bring a breach of contract, to say we're stopping and we're suing you for breach of contract. Well, because you failed. Wait a second. Because you failed to reveal this or that, you failed to make the conditions of the work proper, whatever the litany of complaints that Atsalis had. But Atsalis didn't go down that road. Instead, Atsalis continued working, and I don't know what, you know, I don't get it. What was Atsalis's plan here, that they were going to, at the end, try to get more money out of the department based on some legal theory for breach? I mean, I just don't get it.
Well, Your Honor, with all due respect, that's a fundamental misunderstanding of the undisputed facts here, because Atsalis did assert its rights under the contract and asserted a claim under 104.10. That is how a contractor aggrieved by the department's direction needs to protect itself. A contractor under the standard specs, Your Honor, can't simply just stop work. If they would have stopped work, then there would have been a termination for default. So, Your Honor, with all due respect, they did submit the claim. They told the department. They wrote letters to the department. We are suffering. We are incurring enormous additional costs. They requested the department to.
Okay, but, okay, I appreciate being corrected on that, and you're right, I remember that now, but here's then the question. It seems to me that if I interpret the contract in the manner that you suggest I would, or should, then there are questions of fact regarding whether Atsalis is entitled to the additional compensation that it claims it was entitled to pre-termination for convenience.
Ordinarily, I would say yes. Under the court rules, Your Honor, if you properly agree with our interpretation, and I would like to make a quick record on why we're right.
Yes,
But
I want you to.
if you do agree with our interpretation, Your Honor, the department has testified conclusively, and it's presented in the briefs, that they just took our numbers for what they were. But under the court rules, I recognize that if this court finds that, yes, all pay items were logically eliminated in their entirety when the contract was terminated in its entirety, and we're entitled to payment under 10302F, that's the ruling. Then under MCR 2.116, you got your hearing on damages, Your Honor. But at least at that point, the parties are living within the confines of the contract to determine what are the fair and equitable direct costs that Atsalis incurred in performing the work. And that's why the language of 108.12a remains paramount, because it speaks to situations where the contract begins, the work starts, and then there are exigent circumstances beyond either party's control, such as a differing site condition or altered character of work amounting to significant additional contract costs. That's a quote right from 108.12a. And it clearly contemplates the reality of a construction project such as this one, where the contractor begins its work, they encounter situations beyond their control, and on high multi-million-dollar projects such as these, the costs exponentially increase, Your Honor. And that's why the termination for convenience provision is there, to allow the department to terminate, to minimize its costs moving forward, but to fairly and equitably compensate the contractor for the impacts that they've already suffered in performing the work. So, with respect to why our interpretation of 108.12 is accurate, again, you start with the reasons for termination. It's not the fault of the department. It's not the fault of the contractor. So the contract looks to 10302 to fairly and equitably compensate the contractor. And the reason why the department's argument utterly fails is because if you take the position that a pay item is only entirely eliminated when there's no work done under that pay item, then there are no direct costs compensable under 10302F. It's nonsensical. Time and again, the department says in its briefs that 10302F only applies to direct costs incurred in anticipation of the work. That does not make any sense. A contractor does not incur direct costs on a pay item unless they're actually doing the work on that pay item. As an example, based on the department's rationale, 10302F would essentially become nugatory. You would have no direct labor costs compensable to a contractor because the only labor costs, according to the department, would be payable in anticipation of work performed. It's non-existent. It doesn't make any sense. Likewise, material costs. If you buy into the department's argument that a pay item is only eliminated in its entirety if no work has been performed, then no materials by definition have been incorporated into that pay item. 108.12 already speaks precisely to that situation in the second paragraph, where the department may choose to purchase from the contractor acceptable materials obtained for the work, but not used at actual cost. So based on the department's rationale, the second paragraph of 108.12 becomes surplusage. It just doesn't matter. And taking a step back again, the argument that they're making that 103.02 only applies to costs incurred for uncompleted work, it just doesn't make any sense. There are no costs incurred for uncompleted work. A contractor incurs direct costs in performing its work while performing its work, not the other way around. The 103.02 cannot be held to only apply in situations where costs are incurred in anticipation of. It's just simply not logical. And that's one of the reasons why we gave Your Honor the 2020 version of the standard specifications that have been published by the department. To be sure, this contract is the 2012 specs. Every so often, the state of Michigan revises its standard spec book. The most recent version is the 2020 standard specs. So what I did, Your Honor, is I provided you in Exhibit 8 to our response how the department revised 103.02F. And now in the 2020 version, it reads exactly how the department wants it to read in this case, but it doesn't say it in this case. If this contract had incorporated the 2020 version, they may have an argument, because the 2020 version says the department will compensate the contractor a fair and equitable amount for all direct costs incurred on the portion of pay item work not yet completed prior to the elimination of the pay item. That's the exact argument they're making here. But the language in this case does not support what their argument is. Now, to address the second, they put a lot of stock in the second sentence of 108.12. They say, and by the way, Your Honor, they don't address in the written briefs and what I've heard today, they don't respond to our argument that based on their rationale, there'd be never any direct labor costs recoverable under 103.02, and the material costs would render that second paragraph of 108.12 entirely duplicative. And it would result in an absurd result, Your Honor, by compensating a contractor for costs that have never been incurred. It just doesn't make any sense. With respect to the second sentence, Your Honor, of 108.12, that sentence, second sentence, obviously only can apply to either partially terminated pay items or pay items that are left undisturbed by a termination. And that's because, again, the last sentence, entirely eliminated pay items are dealt with in 103.02F. That leaves the second sentence dealing with either undisturbed pay items, which is an entire possibility because remember, the department can either eliminate all or a portion of a contract. So it's entirely feasible, Your Honor, where exigent circumstances exist that affect only a part of the work. So the department makes a determination, we're going to terminate this part of the work, this other part of the work, and those pay items are going to proceed unimpacted. So what's the second sentence say? It says that the department can choose to pay for those items based on contract unit price or force account. Equally important, Your Honor, is the recognition in that second sentence by reference to force account. Force account under this contract has a very unique definition under 109.05. Your Honor spoke earlier about whether you're looking backward or looking forward. Well, when you speak in terms of force account, the parties are looking forward because it's a situation where the department and the contractor recognize there's a problem and there needs to be a revision to the contract, whether to increase the price, increase the time, adjust the scope, whatever the case may be. But there's no question that under 109.05 force account, the department and the contractor are supposed to get together, develop a plan, arrive at a price, and perform the revised work. Force account work is clearly work looking forward. Take that concept and bring it right back to the second sentence in 108.12. The reference to force account in that second sentence clearly applies to work looking forward. If you're going to do work based on force account, that's where the department and contractor get together today and arrive at a plan for the work moving forward.
But what about the next phrase, as determined by the engineer? So if the engineer determines that the payment's going to be made for completed or partially completed work as of that date at the contract unit prices, isn't that just the option of the engineer?
It certainly is the option of the engineer. But again, it only applies to pay items that are left undisturbed in the termination or partially eliminated pay items in the termination. So you take a partial termination or a partial elimination of a pay item and you're looking forward, and the engineer is going to determine whether or not the impacts necessitate an adjustment under force account or whether you just look to unit price. So again, the second sentence of 108.12 does not refer to eliminated pay items in their entirety. That's why the last sentence for eliminated pay items in their entirety directs you back to 103.02F. And it's nonsensical to take the position that those costs under 103.02F are for costs that haven't been incurred. In light of what's said under 108.12A, the reasons for termination that are beyond the control of either party and without fault. The contractor has incurred those costs in performing the work. And that's why the contract allows the department to terminate for convenience, eliminate pay items, and then fairly and equitably pay the contractor, because the contractor was already trying to work through the impacts.
Okay, I get it. Mr. Tuttle?
Thank you, Your Honor. There was a lot there. I will do my best to be brief. I really will. I know I do have a tendency to ramble on. I will keep that under control. Some points that should be made. MDOT agrees with Atsalis in its claim that no direct labor costs are paid under 103.02F. But we don't believe it's nonsensical. Atsalis is completely correct that if you have labor costs for men working, then you're doing work. So that's completed work that gets paid for. Let me give you some examples of costs that would be covered under 103.2F when you use the gatekeeping function of 108.12. So some of those costs are materials. Atsalis points to the 5th sentence of 108.12 and says, well, that's nonsensical because the 5th sentence allows for payment of materials. But that 5th sentence, which concerns the purchase of materials by MDOT, is completely discretionary. In other words, MDOT can decide, I don't want to buy your materials. But if it decides it doesn't want to buy the materials, then they have to be paid under 103.02F if they were purchased before the work was started. Now, there's another example. There's equipment rentals, Your Honor. For example, a contractor can rent equipment to start work, and then termination could come along, and now the contractor's out of pocket for a whole bunch of rental equipment costs. Construction equipment isn't cheap, Your Honor. You can't, and so 103.02F compensates the contractor for those expenses. Another example, subcontracting fees. A prime contractor hires subcontractors. In this instance, Atsalis hired Smith's Waterproofing. There could have been costs for hiring a subcontractor that's then no longer used, right? The subcontractor's gonna want some payment, and it's gonna be built into the subcontract for basically losing the ability to perform work because of the termination. So there are costs. It's not absurd, Your Honor. There are costs that a contractor can incur that need to be compensated. Now, but it's very clear that the contract language, the fairly bargained for contract language in 108.12 contains a threshold, a limitation on the operation of 103.02F. And it says it's pay items that are eliminated in their entirety by the termination. That cannot be ignored. And Your Honor, you are correct to look to the 2nd sentence of 108.12 about completed work, partially completed work, completed work. Atsalis says that this provision looks forward, but the terms are past tense. So I don't know how it's looking forward if it's talking about completed work. The work's been completed prior to the termination, and that's what needs to be paid. That's clear. There's no other way to read that. And it works an absurdity to say that MDOT can terminate a contract and deny a contractor earned profit. That's what this would do. It works to an advantage for Atsalis because Atsalis, right, did not begin work for 9 months. Atsalis likes to say circumstances were outside of its control. In its own construction contracts, it admitted that it was its failure to manage its own resources as to why they were late. So this notion that there are circumstances beyond their control is not entirely accurate, and the language doesn't even require it. It could be circumstances outside of MDOT's control. And that's exactly what happened here. No matter what MDOT did, it couldn't get Atsalis to do the work on time. And here's another point, Your Honor, that I'd like to make, and that is that if you view the costs as not covered by contract pricing, if you instead view the costs as Atsalis would say, and that is covered under 103.02F, and therefore they must be paid, then there absolutely is factual issues. For instance, they include in their cost submission attorney's fees. Those are not fees. Those are not costs incurred in performing the work. Those are something else. They also include markup. So they're boosting their direct costs with markup, which is not covered under 103.02F. Yes, 103.02F says equitable and fair, but that doesn't mean necessarily markup. They're basically trying to renegotiate their bid price because they overextended themselves on this contract. They were 9 months late and they couldn't perform the work. And they saw a loophole, what they thought was a loophole. And that's exactly right, that their plan was to push their costs up over and over and over, and then finally argue a contract provision to the court, which in a sense, I guess they're doing right now. The notion that MDOT took their numbers for what they were, this is what Atsalis has just said, that regarding why its position that there's no factual issues regarding the costs is because, quote, MDOT took their numbers for what they were. Atsalis's position is that the numbers are substantiated, the costs are substantiated, all 1,700 pages of it, because MDOT didn't write a formal objection somehow. MDOT did not accept their costs. MDOT has not accepted their costs from the beginning. It combed through the costs. This is established by MDOT's representative, Carrie Warren. She testified that she combed through those costs. She compared them to the inspector daily reports that reported all the work done. She looked at what equipment was there, what equipment was used. She examined all of this. And after that examination, determined that only $500,000 of the $16 million in costs was actually incurred either through completed work or through anticipatory work, namely the material, the blasting material, which was paid for. And you're also correct, Your Honor, that the differing site condition claim, the extra work claim, those claims are deeply embedded with factual issues. The differing site condition relates to something called scotch coat. And the question is does it take longer to blast clean scotch coat?
Yes, we covered that
Yeah.
last time around. I'm a little senile, but I still remember scotch
Okay.
coat.
All right. Thank you, Your Honor. Thank you. So in other words, that's a factual issue. Now, if you look at the contract, post-termination payment compensation as requiring contract unit prices, that factual issue is gone. But if you look at it as an actual extra cost, then there's the whole question of, is it an actual extra cost? Did they actually incur more cost cleaning scotch coat or not? So as I'd like to stress, or as I am stressing, Your Honor, the question of post-termination compensation is separate from the extra work claims. This court can decide the post-termination compensation. Did we pay it correctly? And then move on. The parties can move on to the extra work costs. Did the contract require complete cleaning, or did it require only partial cleaning? Was scotch coat a differing condition? Was the platform and containment provisions, were they unworkable, as Atsalis alleges? Those are factual issues that do not need to be decided to decide MDOT's motion. As for the 2020 revisions, Your Honor, a quick review of those shows that MDOT is—
You don't need to speak to those. I'm not really that persuaded that makes any
Okay.
difference here.
Then I believe, Your Honor, that I just want to say then that the second sentence of 108.12, if interpreted as Atsalis claims, it creates great inequities for all other contractors. They lose their right to earn profit. It creates a one-day loophole for MDOT where it could somehow terminate a contract, but say, hey, we're not terminating today, we're going to do it tomorrow. So stay there one more day, and then all of a sudden we have these abilities to eliminate earned profit and other such things. It just doesn't make any sense. Atsalis is trying to renegotiate its bid prices here because it couldn't keep its costs under control. And the contract says you get contract pricing. And when you view it as contract pricing, it eliminates all the factual questions there. Payment can be made, parties can move on, and we can move on to the extra work claims. Thank you, Your Honor.
All right. Thank you, counsel. It's helpful. I'm not sure either of them are easy. I knew the one that was just argued, the second argument, this is a difficult and challenging question, which leads me to the global, as I said, we were going to speak globally today, and we are. This case, it seems to me, could go on for another 2 years, because I could theoretically determine that there are fact questions as to both issues that were raised, both motions, and that would be sort of, I'll characterize it as a pox on both your houses. You get to litigate more and more and more. You get to spend more money. You get to spend more time. You get to have a trial that I think could go on. From what I'm hearing, this trial could go on for 2 or 3 weeks. So yeah, I mean, this is a monster of a case in some ways. So it seems to me that at least in the interest of not only judicial economy, but lawyer economy and economy for Atsalis, economy for the state of Michigan and everyone else, that now is the time to try to see if this case can be facilitated. I know the department's not crazy about that idea, but Atsalis has proposed it. And it seems to me that we're at the brink of, should I decide that there are questions of fact here, more discovery, more trial. And, that doesn't seem to serve anybody's interests. Now, yes, I recognize that the distance between the parties on a dollar basis is enormous. So finding common ground is probably not going to be easy. But I do want to start thinking about and pointing you in the direction of facilitation. And I want to talk about that and get your thoughts about that this morning or whatever time it is. I guess it's afternoon. Second, I'm wondering whether it's even worth doing anything in this case, my deciding these issues and moving toward facilitation while the case is still pending in the Court of Appeals. I think it's still pending in the Court of Appeals. I haven't been notified that it's not. Mr. Vitigo, is the application still pending?
It is, Your Honor, as far as I know.
Okay. Generally, obviously I can't look it up, but generally those are decided pretty quickly with at most 3 months turnaround. Now, this record is enormous, so it might be taking the court a little bit longer in this case to decide it. But, I think that what I could envision happening if the court grants the relief you seek is that the department's going to file a cross appeal on the issues that the department lost. At least that's what I would anticipate. And if that happens, this is going to be, held up in the Court of Appeals for 2 years, or we're actually faster than that at the moment, about 19 months. But anyway, I mean, and I'll lose jurisdiction probably anyway, happily. So that's one option, is to do nothing until the Court of Appeals decides what it's going to do. And I think I'm going to do that with regard to these motions. I'm going to hold the decision on these motions until the Court of Appeals decides whether or not it's going to grant the application. That's number one. But number two, even before that happens, I think perhaps we could move toward some facilitation. I know it won't be happily embraced by the department, but as I understand the court rules, it's within my authority to order it, and I'm definitely leaning strongly in that direction. So I guess theoretically, department, Mr. Tuttle, Mr. Khan, you could object with a motion if I order it, or you could file an objection. And I'm not going to force you at this moment in time to tell me what you're going to do. But I mean, I'd like to hear some preview of that so it can inform my decision as to whether or not to enforce or to order facilitation. But I think the harder question is, if the court does order facilitation, how do we determine who can facilitate this? Now, I've certainly seen cases. I haven't had any. This is the first, as you know, I'm a newbie to the Court of Claims, sort of. But I haven't had any construction cases. But I've read some in which there are very specialized facilitators who are out there and available to do facilitation in a massive case like this. And I don't know if you guys know some, but that would be, a possibility that you submit names to the court, or, God forbid, you should be able to agree on a name. I guess that would be asking for the sun, the moon, and the stars, but that would be a nice prospect if it's even possible. But I've talked enough here. You understand where I'm going. Mr. Vitigo, I'm going to let you as the plaintiff speak first, and then defense counsel can talk. What's your reaction?
With respect to facilitation, Your Honor, we would welcome that. I believe back in May or June, I proposed 4 or 5 names to the department and the Attorney General's office in a letter. So I can go back and look at that list again. I can give another list. Your Honor is correct that there are attorneys that specialize in facilitating construction disputes. And if for some reason, the Attorney General's office and myself and my client can't agree on somebody, I guess I would propose, Your Honor, that we each submit a list to Your Honor for her to select.
Mr. Tuttle or Mr. Khan, whoever wants to speak to that.
I get the rest of it, Judge. So Mr. Tuttle got to have the fun part, and now I get to deal with the rest of it. So, I vaguely remember Mr. Vitilio sending us names. I don't recall off the top of my head who they are. So I can't speak to whether or not any of them would be agreeable, but you're going to be surprised to hear me, fine, Judge, to say that I agree with Mr. Vitilio. The two sides can't agree to a person, then we submit a list to Your Honor, and Your Honor make the choice. That's done in some of the circuits as well. So that's not a new thing that either one of us have heard before. But I do want to speak to facilitation in general. It's difficult to have this conversation, so I'm going to tread lightly because you are the ultimate trier of fact, and thus negotiations can't be made a part of any of your knowledge. But the state was actually the first to approach and to attempt to engage in settlement discussions. Even before the motions for summary disposition were filed previously, we solicited a demand. And quite frankly, at every step of the process, it's been frustrated to the chagrin of the department because we would like to move forward. And a part of that are some of the reasons that you've identified here today. So for that being said, Your Honor, it would be our strong preference. Personally, by the way, I'm never opposed to facilitation. The department's never opposed to facilitation. But some of these issues that are hanging out there do need to be resolved. And
I get it. I get it. Yeah, I understand exactly what you're saying. The facilitation would be helped along by a decision, at least on some of the, on at least one of the motions today, and probably both. So I get that.
You said it way better than I ever could have, Judge, because I was trying to tiptoe around probably a little.
No, I get it. I mean, I didn't do construction cases, but I did litigation for a long time. So I understand that you need a framework for the facilitator, and you don't want to pay the facilitator for time that you don't need to spend, that he or she doesn't need to spend working through these issues. So here's what it seems to me we should do. Get me, each of you, why don't you 2, 3, 5, however many lawyers you want to put into the mix, get together, both sides get together, spend the next 2 weeks, see if you can come up with a facilitator. If you can't in 14 days, let me know. And at the same time, submit your list of names. And I presume you'll submit resumes or some background information. So it's not like I throw the names up into a fishbowl and pick one out. So that's going to be a 14-day requirement. Meanwhile, it's possible that the Court of Appeals will act. If the Court of Appeals denies leave, then I'm going to go ahead and deny the motion. Not deny the motions. I'm going to go ahead and consider the motions. So I will decide the motions, and that will then provide the facilitator that I will subsequently select if you can't select one, with basically ground rules or a circumscribed frame in which to work, if that makes sense. if the Court of Appeals does grant leave, then everything's on hold. So
Would you issue a stay order and?
I would. I'm not doing any more work until the court, I mean, the two issues that are, or the issue that is in front of the Court of Appeals, and I don't have Mr. Vitiglio's brief in the Court of Appeals. Now that I think I could get, but I haven't asked for it, and I don't want to read it at this point. If the court grants, great. If they, for Mr. Vitiglio, if they don't, we move forward. But I presume that it wouldn't make sense to spend more money and more time on your parts if the case is in the Court of Appeals on a large issue. So it's like the notice issue or whatever issue that it's up there on. It doesn't matter to me at this moment in time. But that's where I'm going.
Your Honor, one point on that topic would be that in your thinking, does it, the issue on the liquidated damages is something that is not presently part of the application for leave?
Yeah, no, I can decide that. I mean, that's, as I said, that's the easier, it still remains easier to me in my head than, I mean, you've both given me more to think about today. So you've all made it harder than it was coming in here, but that's a good thing. I mean, that's a good thing for a judge because it means I missed something. It gives me more to look at and more to think about. So it is a more difficult issue than I thought, but I agree with you, Mr. Vitiglio. That one is certainly something that can be decided before facilitation if we move in that direction.
Okay.
And it will be decided, assuming the Court of Appeals doesn't put us all off the track for a while.
And while we are on the record, Your Honor, may I briefly address two more parts of the argument going back to 10302? Have you heard enough?
No, I've heard enough. I really have. You're going to be at risk of making me too tired at this point of listening to this argument. I mean, I get it. This is in large measure something I do every day as a Court of Appeals judge. That is, I interpret language. So a big part of this is, what does this language mean? And I'll be informed by the totality of the document, the standard specs and the case law. And I think I understand enough to make a decision that's going to be rational. Might not agree with it, but it'll be somewhat rational. And my law clerk is listening to all of this, so he can, he'll be sure to steer me in a more rational direction. So
we'll blame him for the irrational portions, assuming they're all.
yeah, right. I'll take all the blame for the irrational. Okay, so the next step then is for you to see if you can get together on a facilitator. I'll enter an order that in 2 weeks you're to either advise me that you've named a facilitator or that I've got to pick one.
Okay.
In that regard, Your Honor, just while we're on the record and I have Anthony's attention, Anthony, assuming that you did, and as I said, I don't remember, but assuming you did send us some facilitators, do you want us to look at those or do you want to propose new ones and send it to us?
I'll send you a new list.
Okay. Okay, that works. And then we'll take a look at that. And if we have agreement, great. If we have proposed responses, we'll let you know what those are, but we'll work through those issues.
Okay, anything else at this moment?
Your Honor, you did ask us for a letter, I think before the end of the year, about discovery and whatnot. I don't think it's going to come as a large surprise to you that the discovery is stalled. In this case, pending the motions.
Right. And it's better that way, because I don't want you, if you can resolve this case, I really want you to do that rather than spending more time and money on discovery.
So as to kind of put the department at ease with what it wants to do in terms of discovery, does it make sense to stay discovery until we're outside at least of the Court of Appeals?
Yeah, I'll put that in the order.
Okay, thank you, Your Honor.
Okay, anything else? Ms.
Not for me.
Roberts? Okay, when you have a chance, please, a copy for me. of the transcript of today. And I'll look forward to hearing from you in 2 weeks.
Thank you,
Can we
Judge.
request a copy of the transcript as well, please?
Okay, Mr. Conley. Mr.
Thank you so much.
Do you want a copy?
Yes, please. Thanks.
Just electronic is okay?
Whatever makes it easier for you. Yeah. that'd be great.
Electronics, fine. Yep,
Yeah,
for
okay.
me too.
Okay, thank you.
All right, thanks, everybody.
Thank you, Judge.
Thank you, Your Honor. Have a great
Thank you.
day.